Good morning and welcome to Law and Order. So basically, when it comes to this program Law and Order, you'll be having certain answers for your legal issues. So we were discussing about family in our previous episode. Now basically, when it comes to the family law, divorce, we have a lot to discuss, and today's program will also be focusing on certain consequences with divorce and certain marriage after effects, and we are going to discuss about them as well. So today our guest is Mr. Ian Fernando, attorney at law and senior counsel. Thank you very much, sir, for joining with us with today's program as well. And basically, when it comes to divorce, we discussed in our previous episode about the grounds and the certain case laws, how it affects the general public, and certain advices we gave for those things, the general public to proceed even with a court case. Also, when it comes to the children, it plays a prominent role, and we were focusing a small area about children as well. So children plays an important role when it comes to the family, which is the fundamental unit of the society. But we heard that, and it's prominent, that children's voice is not heard like thing in certain divorce issue. So as a counsel and as a general individual in the country, how can you focus that on?
Certain people in the legal fraternity use the children as a pawn in the divorce case and try to give documents from them and lead their evidence in court. But that type of behavior is frowned upon by the judges unless it has created a calamity to the child, so much so that it should be brought to court. Because that same evidence can be given by either spouse stating facts, but just to make things difficult for the either spouse, sometimes people in the legal fraternity may use those children in such a manner to gain their objectives in the divorce case. They might use the children.
Yes, that means as the upper guardian, the court concerns a lot about children.
The court is very concerned about the children, and the court doesn't allow that to happen.
Right.
Court is very. So coming to their property rights, now in a divorce case, the property rights devolve this way. In a divorce case, you cannot share or try a settlement in property rights, because 43 New Law Reports, page 272, in the judgment of Senadipati versus Senadipati, it was clearly set out that if you have any property rights to be divided, that can be done in the divorce case. You have to file a separate action for your recovery of your property.
That means if we want to give some property divided for the children, we have to file a separate case.
Not exactly. You cannot come into a property settlement in a divorce case. You are partly correct there.
Right.
But however, in 1989, one Sri Lanka law report at page 180, in the case of Samarsingh versus Samarsingh, that judgment was slightly varied to say, if the plaintiff files action against the defendant, and if the defendant is moving for dismissal of the plaintiff, then there can be property rights that can be sorted out. However, if the defendant moves also for a divorce, not dismissal, account the divorce, you won't be able to settle property rights in the divorce case. So there was the advancement of the law. So it's always better when there are property rights issued, which are issues, to settle them prior to the granting of the divorce. Where you come into a consent agreement where parties will transfer their properties and call it square, and then file the divorce case, which is very simple. Then either party will take upon the responsibility of being the guilty party.
Right.
And the guilty party certainly forfeits whatever property rights benefits. That is the law of the land.
Right. That means to fulfill our objectives with divorce, and when it comes to the property, without making it a mess, putting everything together, sorting out the property initially and then moving to the divorce
is much easier.
Much easier, and with
and more prudent.
More prudent. Right.
It's a wise move.
Wise move. Right. With that proper and correct instructions, they can move ahead without putting everything together. First sort out the property issue, then comes to the divorce.
Correct.
Right. So basically, when it comes to that, if property is embedded somehow faultly or even with a certain misguidance, even with that property including in a certain divorce matter, if they are jumbled. So as we talked previously, we heard that if with proper instructions, the divorce will run like within a limited period of time and we can sort it out. When this thing is a mess, what will happen for the time period?
Mr. Sarathy, we can do this in a issue like that. You can concede that we take up only the grounds of divorce because there is the answer being filed contesting the divorce. They are not asking for dismissal, and you can move the property rights out and file cases for the property rights and come to an agreement and consensus on the property rights.
Right.
So that will be making it much easier.
Much easier. So already
sometimes even the courts will ask them to sort out their property rights and then come to court. That what most of the judges advocate.
So if it is a mess for the moment also, we can sort it out initially and come to this case later on. Right. So basically with that property thing, I'm going to shift basically to children. So when it comes to the age limit of children, so I'm going to focus this question basically not with the point of law, but as the ordinary individual, how he or she sees this thing, how that age limit of a child is considered in a divorce case.
In the age limit of a child is considered 18 years as the time prior to that, where the custody and maintenance orders can be made by court.
Right.
But the Maintenance Act has now come of age and it has been amended to say that a child's maintenance can be given up to the age of 25 or in the alternative to the first degree that that person does. So if you finish your first degree at 23 and you are in a working capacity, the maintenance won't be granted. But otherwise up to 25 years, whether with or without the degree, you are entitled to be getting maintenance from your father or the mother. And the maintenance will decide if the mother is earning more than the father. Sometimes court may ask that how these payments are made before the death, before the divorce, rather, and then act accordingly. If the father has been paying, the father will be asked to pay, or if the mother is earning more, the mother will be asked to pay. And if the mother files a maintenance case against the father for money for maintenance ordinance, that party or spouse will not be entitled to any maintenance at all.
Any maintenance at all. So what are the other backgrounds which will prove that there is no maintenance? So apart from that issue.
Apart from committing adultery, you can take up the situation that the assets that the other party has are much more. The other party has been maintaining the child, and therefore you have been only contributing a negligible amount. So you are in a maintenance case going to see prior to the divorce how the position was, and post, once the divorce case is pending, how the position is, and act according to the past. The maintenance is calculated in a particular format which is normally not set out in the law, but how it goes is that for the past preceding 5 years, you take the total salary, divide it from the number of years, then you will get a figure. You are entitled to not less than 1/5 of that figure. For example, if you are earning 100,000 rupees a month, then you will be having 6 million with you at the end of 12 years, 5 years.
5 years.
So you divided by 12, then you get the particular amount. So it will be not less than 1/5 the maintenance will be ordered.
Right. For an example, if a child is like he wants more than that 1/5 for his basic needs, not for something fancy or something unessential, he needs really more. In that case, can a child, or rather for that maintenance, can we claim a little bit more than that?
Yes, put it in a nutshell. For example, if you are having a particular child who wants to go and do his education in Oxford or Cambridge, which is not viable for the parent to do that. Sometimes the same educational program might be able to be done in Sri Lanka on an online composition, which is much less. So you can't demand for more maintenance, though it's even education. But you can certainly ask for certain factors where you need money, but that must be proved by the particular party asking for maintenance, on what grounds and what basis that person is asking for that money.
That means the demand should be reasonable.
Demand should be reasonable, and the demand must be with proof. If you are going abroad for your studies, then you must have tabled the university you are going, how much the expenses are, which university you are going. so that whether that is within the reach of the other spouse to send you abroad.
Abroad, right. So basically moving a little bit out from that, each and every time when a divorce happen, is the custody of that children granted to the parents, or there are any exceptions?
There are exceptions. Sometimes the grandparents I have seen getting custody of the children, because if the parties are fighting continuously within each other and the particular place is not a suitable place for the children to live in, sometimes I have seen in few instances where the grandparents are given to nurture the children with access to the parents, and which is supervised very regularly by court through their probation officers and the other court machinery.
Right. Okay. So when it comes to a certain legislature and a certain institution, National Child Protection Authority, what is the role of that
They
institute?
play a very major role now in Sri Lanka. They are headed by very good legal personnel who are very keen, but the act itself, I would say, would need little more teeth in the act, because certain acts can't be done totally by them, but they do real protection of the child. They bring in the parents and they have some counseling sometimes and try to sort out the issues. They are doing a yeoman service to our country.
Right. So that is the National Child Protection Authority. And apart from that, like for an example, think a child is there, he is suffering from a certain injustice or a certain thing from parents which is not justifiable. Can that child claim to that National Child?
Yes, through that the child can, through a spouse basically, or make an application and say that there is domestic violence caused to that particular child.
Right.
But sometimes the children might think that just because a parent reprimands a child,
Right.
slaps a child,
A single slap.
slap, or pushes a child, that will amount to domestic violence.
Right.
Not so.
Then,
because there is some degree that the parents could
Right.
reprimand a child, but not reprimand a child to have a real physical injury, which may cause even physical inability later.
Later on.
Just the normal situation is that the Child Protection Authority also recognizes to some extent that there is some influence used, I put the word influence, used by the parents to reprimand their children.
Right. So simply a simple slap won't survive. And when it comes to a certain that the word domestic violence, I'm going to talk on that also. So that domestic violence, like if the parents are quarreling, is it domestic violence for that child?
Domestic violence is between the parents, and domestic violence can be caused by the spouse to the children. So then you can make an application through the police or by private plane, setting out all the grounds. But that domestic violence must be really violence. It must be very well fortified that it's violence, and then court will grant you a time to file your petition. And upon that petition, court will make an order temporarily granting you a particular order restraining the either spouse from coming into the house. Maybe your own house, you might not be able to come in. And after inquiry, the Domestic Violence Act provides you the provisions that for 1 year you will be left out of your house, or that other spouse is not entitled to come into your house, and even the probation officers will be called to have an inquiry and summon the children and go through and find out what necessary order should be made.
Right. So when it comes to that basic domestic violence thing, if a child is injured or tortured, so what can that happen in that situation?
There is two situations. They are injured when you say, if you give a slap to a child, I'm sure you might have a mark on his face,
Yes.
but he is not in a grave difficulty.
Difficulty.
The other situation is a grave situation that you spoke about. Then you can get hospital references and show court that with that slap he lost his eyesight or his hearing dimensions went out, and that will be a grave issue.
Grave issue. Right. With that medical evidence, we can proceed.
Yes.
So
that has to be continuing, happening regularly, not once in a while.
Once in a while. So how can we relate that domestic violence with divorce? Are there any prominent cases?
Yes, the reason there are no prominent cases, there are cases where the spouse tries to show that the next spouse cannot be lived in the same matrimonial house because of domestic violence.
Right.
But court will have to ascertain as to how that domestic violence took place, what construed that to happen, which party was guilty of committing or getting that domestic violence done.
Right.
Court will go that mile to check on that.
Right.
Just because a person said that I have been hit, court is not going to be satisfied that it is a wrongdoing of the spouse. Court will ascertain why was the child hit, under whose influence.
Right. Okay. Simply that domestic violence, like quoting a little bit, moving forward with that, sexual relationship between the spouses, that plays a prominent role when it comes to this family issue. Rejecting that thing, will it be a certain type of domestic
Most
violence?
marriages break down because the either spouse is not being sexually happy, I would put it that way. So, the love and affection and sexual happiness all comes together, not from a legal point, from a social point.
Right.
So, if you can maintain those standards, never will a marriage break down.
Right. So, that plays a prominent role
Very
there.
prominent role. I have seen couples who have come and visited me, who have got back with their spouses, and they are very happy because they have been able to sort out their differences and get back.
Is that through proper consultation?
Proper consultation, proper counseling. I know of an incident where a major businessman who is a fishmonger, who was dealing in fish, had an issue with his wife. Whilst going through counseling, we found that he has the smell of fish when he comes home. That was the issue.
Right.
So, then everything went to the correct place when he was asked how to get rid of that, and then be closer to his wife.
Right.
Where his wife accepted him.
Accepted him. So, like that, when it comes to that sexual relationship, now we talked about how it affects that domestic violence and breakdown of marriages. And when it comes to that penal code offences, criminal offences, rape plays a prominent role. We are not going to discuss rape here, but if that sexual intercourse or whatever that is happening is not with proper consent, will it amounts to a rape when it comes to the matrimonial
You can
thing?
say that there is marital rape, but it is very difficult to prove because either party must consent. And if the either party is not consenting for a long time, like 10 to 15 years, you can take up the position that she has constructively or he has constructively deserted you.
Right. That goes through this malicious desertion.
You can pinpoint it on that because marriage is, there should be some part of love and sexual relationship with the party, but for a considerable amount of years, if you are not allowing the other party to be intimate to you, then that can construe to be constructive malicious desertion.
Right. So,
you don't have to leave the house. That is good enough.
Good enough. Right. So, some people, when it comes to certain mental problems, psychological problems, they have a separate mindset when it comes to this sex. So, if he commits a rape like thing, if he like torture, will it only amounts to a certain malicious desertion and apply for a divorce, or apart from that can we take another legal
You cannot
action?
say that there is marital rape. There can be some inconsistency there in those words, but the spouse, if he is not being intimate and close with the other spouse, that will definitely be a breakdown in the marriage relationship.
Right. So, when it comes to that rape thing, it does not apply with closely
when you are married.
Right. So, for that like successful marriage life, we have to have that thing, but that is not amounting for certain criminal offences and no longer. And for the unity of that spouses and the particular so-called couple, that is essential and prominent. Right. So, then when it comes to, I'm going to talk about a little bit on further maintenance. So,
on the maintenance, Charita, there are two ways that you can apply it. One way is you go to the maintenance court and make an application, the spouse who needs the maintenance. So, that spouse must be able to show that she has no money in her account, that she is a poor person and she needs money to look after these children. The second situation is that she will or he will get into the witness box first. The second situation is a deadly situation, where you come under civil law and under section 614 and 615, you make an ordinance in the first instance, where you ask a party to pay the maintenance and if that party can't pay the maintenance, that party has got to get in the witness box and give evidence first,
Right.
to say why he can't or she can't pay. That's a very stringent provision of our law,
Right.
as in contrast to the maintenance ordinance. Maintenance ordinance, the party who seeks the maintenance goes in and claims the maintenance.
Right.
Under
So-
the civil law, the party who is unable to pay the maintenance has to come first and start the case and show why that person can't pay, because there is a decree NISA entered in the first instance. That is the great difference.
Right. So when it, finally, when it comes to maintenance, is it a particular relief that is granted with divorce?
Maintenance is granted as way of a permanent alimony for divorce for the wife. So there is a lump sum involved in calculating the amount, and there again the court will order that lump sum to the not guilty party as permanent alimony.
Right.
Guilty party will never get any permanent alimony.
Any permanent alimony, right. So we discussed a lot about with the second episode about this matrimonial issues. We discussed about maintenance, custody, domestic violence, and certain sexual relationships, how it amounts to a divorce, and how a particular male and a female, when it combined with a certain word family, how they can proceed with a fruitful, effective way with these children, and to proceed in a manner that they can discuss their issues and come to a certain conclusion with their family concerns. And that is not basically the law courts they have to have, but with proper consultations, counseling and guidance, they can have a fruitful life. So thank you very much, sir, Mr. Ian Fernando, senior counsel and attorney at law, for joining with us with today's program. And we were able to discuss a lot about marriage, divorce, custody throughout the episodes, and thank you very much once again for accepting our invitation. So, Law and Order program basically focusing on your essential legal requirements, advising you all with your legal issues. Basically, we are focusing on the common issues. So stay tuned with Law and Order program. Find solutions for your legal questions. Thank you very much for joining with us. Have a pleasant day.